Good morning, Your Honor.
Mr. Taylor, are you going to reserve 5 minutes, sir?
Yes, Your Honor. I'm going to reserve 5 minutes.
Okay, we're ready to go whenever you are.
Thank you. May it please the court and Your Honors, I am Sean Taylor representing Appellant Bayview Loan Servicing, LLC. In case I don't get to it, I would like to rely upon my briefs for any arguments that I do not reach during this oral argument. And I'd also like to begin with a brief review of a few pertinent issues and standards for this particular case. We are here on an appeal of several orders stemming from an order granting a motion to dismiss the complaint. And under that particular standard, Your Honor, so we're here under the de novo standard of review. And that's because...
Can I interrupt you and ask, in any of those orders, could we perceive that the trial court took judicial notice?
I'm sorry, what was that, Your Honor?
From any of those orders, could it be perceived that the trial court actually did take judicial notice?
No, Your Honor, not from any of those orders, Your Honor.
Mr. Taylor, what really shocks me in this case is that you were given an opportunity to amend your complaint, told exactly how to amend your complaint, give a deadline to amend your complaint, and the Supreme Court decision in Bartram is just out there big, live, you know, in this area of the law. Why didn't you amend?
Yes, Your Honor. Specifically, in this particular regard, the court was striking the amount of damages that the plaintiff could recoup. And so we felt that that was improper for the court to do on a motion to dismiss phase because, as I'll get later into in my briefs, what the court did in this particular case...
striking of damages, or was it that this is something I really want to get to because you brought up what you all thought the court was doing, or was it that it was dismissing because you alleged a default date that was barred by collateral estoppel? In other words, collateral estoppel, yeah, you're not supposed to usually consider that at a motion to dismiss phase unless it appears on the face of the complaint. Assuming for the sake of discussion that judicial notice was properly taken, was it not clear on the face of the complaint that the issue, that the default date was collaterally estopped? And if that default date was collaterally estopped by a dismissal with prejudice, didn't you need to actually file a new complaint that alleged a later default date?
Respectfully, Your Honor, I believe that as we pled it, it was a period of default, a continuous period of default. When we get to an issue of proof, because we can basically illustrate that the defendants in this, the appellees in this particular case were in a period of continuous default. And that's why I believe I included some of that Bartram language, Your Honors, and there's also, I think, the DeSylvester case from this particular DCA that gets into that fact of when you allege a continuous period of default, you're alleging every single one of those defaults. And so for a shorthand, we're not saying, you know, every single month up until the day of filing of the complaint. And so that's why I think
I'm assuming at this stage, so I'm following, I think I just have a question, and I don't want to inject into this discussion things that really weren't raised, but this is at a stage at which you probably, if I don't recall right offhand, but your complaint probably said you applied, you know, all conditions, you know, you satisfied all conditions precedent, and that's probably like your default and cure letter, right?
Yes, Your Honor, I believe that.
So in other words, can we delve into whether that we were relying on the same, you know, notice and cure letter, the same default letter? Or is it, if that's outside the record, just say right now? I assume it's outside the record.
I think it is slightly outside the record, Your Honor. I just don't have, if I can recall, I think a new letter was sent after the new filing, but it basically advanced the default 1 month forward. And I think that's something contained within the record. So
1 month after the default alleged in the 2013 complaint?
Yes, Your Honor. I believe 1 month
why
forward.
Isn't that still a problem if you said, oh, well, you know, it wasn't the trial court said, well, the default, any defaulted payments, missed payments between whatever 2013, 2015 are barred by claim, you know, issue preclusion.
That's the thing, Your Honor. I think we haven't gotten to that point because, for the sake of argument, when you get to that factual finding, that determination, you're allowed to rebut, present evidence in opposition, present defenses to that particular issue. And we didn't even get that opportunity. And so that's why, via the Anheuser-Busch.
Assuming that judicial notice was properly taken, which you're not conceding, the trial court was premature to say, hey, you can't base this default, your default on a time period prior to, during which those payments were issued precluded.
Yes, Ron,
that's what you're saying. So go on.
Because in collateral estoppel, to even get to that point, the court has to make fact findings. And we were there on a motion calendar, not an evidentiary hearing, on a motion to dismiss, which tests the sufficiency of the complaint to state a cause of action. We specifically in the complaint alleged the duty and the contractual obligation, which was contained in paragraph 3 of 4 of the complaint. And the complaint in this particular case, Your Honor, is found on record page 13 through 38. The breach of that particular contract, which is contained within paragraph 7 of the complaint, and the damages alleged by that contract, the breach of that contract, was contained in paragraphs 10 through 11 of the complaint. And so I felt that we sufficiently stated a cause of action under that particular standard of review. And so kind of going back to the issue is, in this court, basically, whether to dismiss a complaint is a pure question of law, Your Honor. It's not the fact. And I think this panel and almost every single DCA has held that when you're considering a motion to dismiss, you do not go outside of the four corners. And it's only under that very rare and narrow exception upon which the appellee concedes in their own motion to dismiss, it does not apply. And kind of going forward, Your Honors.
Okay, but let's would you mind talking about the judicial notice? Judicial.
Sure, Your Honor.
Isn't there an exception for, and I think you drew a distinction between collateral estoppel and res judicata. I'm not sure that's borne out by the case law or not, but my inclination thinks it's not. It's any if some sort of preclusive, some sort of prior decision had a preclusive effect that would, on its face, require dismissal as a matter of law. Why isn't that capable of being determined in a motion to dismiss if judicial notice was properly taken?
Yes, Your Honor. I think you're going to get to the Seminole case. Let me just make sure I get to it so I can give it to you. I think it's the Seminole v. McCord case, Your Honor. And that's from this District Court of Appeals, which illustrates the two-prong test, Your Honor. That defense must first appear on the face of the complaint and judicial notice is properly taken. So it's not an or, one or the other. You have to have the two-part test satisfied. You have to have that the fact of the prior action is referred to in the initial complaint, and then you get to that, did you take judicial notice properly? And
is there a case law that goes another way, that isn't quite as strict?
Well, not from this DCA, Your Honor.
How about from another DCA?
Well, I guess that gets into the part of stare decisis, but regarding, I believe the court relied upon a 1999 case, and the Seminole Tribe versus McCord case was decided later. So I think that would be the presidential case for this particular court to follow.
What should we do? You're talking about the all pro sports case?
Yes, Your Honor.
What should we do? I mean, what should we follow? And how does that case, what is the reasoning applicable? And should we follow? I'm assuming you think we ought not to. If it is applicable and it's in favor of the appellee, you think we shouldn't follow, but why?
Well, I don't think it's applicable, Your Honor, but I'm also going to get into another issue where is the court, the lower tribunal court in that particular case, they also relied upon their own circuit court decision, which I believe that goes back to stare decisis, that they were bound to follow the second DCA, and in their attempt to find a decision to support their reasoning, I think that they should have followed, were improper in that and created an error in this particular case.
If within that decision, that circuit court decision, which I think it was the Judge Carroll's own decision, he thought, I liked the conclusion I reached before. I just referring you to this reasoning, and that's what I'm going to go with again. If that's based on case law that supports his conclusion, then there's no per se problem with them just referring us to his previous reasoning. My question was about the all pro sports case and whether since we're not bound by either the All Pro Sports case or is it the Parrott case? No, what's the other? No, Parrott's the circuit court case, the first DCA's case. Can you please tell us why, or tell me why you think All Pro Sports doesn't support the opposing party?
Sure thing, Your Honor. All Pro Sports case, I believe, was not a case regarding a installment contract such as this particular case, Your Honor. I believe it was, I don't remember the exact nature of the case, but I think it was not an installment contract case, which has a completely, I think, special distinction because there's that optional acceleration clause within these installment contracts, which allows them, and it's not, once a case is dismissed, it doesn't mean that, the mortgage is extinguished, the loan released. It does not mean that, you still have a valid lien on the property. And so that's one of the contentions for distinction.
So in the All Pro Sports, they could take judicial notice of this other case because it wasn't an installment contract type case here, like a foreclosure, because it would be a cut and dried matter. But
yes,
here you can't take it. So here, but my other question is, under All Pro Sports, could the court take judicial notice to determine whether that prior case had preclusive effect? You're saying, well, that it was cut and dried. The case had preclusive effect. Here, it's not so cut and dried because this is, this is an installment contract of sorts.
And I believe that the All Pro Sports case was one that there was the federal case, and then they were trying to determine whether the federal case had come back down when it was filed in the state court case, whether that was a preclusive effect because of federal jurisdiction. And that's where another distinction that doesn't happen in this particular case, Your Honor. A federal, they were trying to determine whether these issues were decided in the federal court case and whether or not they could actually be decided in the state court case. And so that's another area of distinction because we're dealing with two state court level cases, circuit court level cases, Your Honor. But that, we're all assuming arguendo that it's proper to go outside the four corners of the complaint. That being said, I still don't think we reached that particular point because the actual case law and conceded by appellee in this particular matter, and I believe in their motion to dismiss on page, I think it's 320. Let me make sure I get it correct.
Well, that's okay. We could probably find it. You can just tell us what you think it says.
Yes, Your Honors. So the motion to dismiss is on page 321 to 324, and I believe it's page 322, where they concede under the first DCA case that they utilize that it's generally improper for a court to take to take consideration of facts outside the four corners of the complaint, and kind of discussing the Parrott case that was relied upon by the circuit court case. That case has numerous distinctions that do not make it applicable to this particular case, Your Honor. And in that Parrott v. Willis case, Your Honor, the court repeatedly in that particular case, and those litigants particularly repeatedly made references in their complaints to prior actions. That's how they satisfied that first prong that would allow them to then satisfy the second prong of allowing judicial notice to basically allow the collateral estoppel defenses or res judicata defenses in those particular cases to be applied on a motion to dismiss. They met the very narrow, rare exception, and I think perhaps the lower court did not recall those facts in its order because, respectfully, Your Honors, that case was never presented to the appellant at the lower court case level. It's basically something that the court said, hey, I made this other ruling in a prior case. You were never a party to that. You were never briefed on these particular issues, and I'm just going to utilize that case findings for my decisions here. And that's why we thought that was also basically improper because you don't give the parties an appropriate time to prepare a response in opposition to that particular ruling. But going back to this DCA, Your Honor, that's the Bowles v. State Farm Mutual Auto Insurance Company case 679 Southern 2nd out of the Florida 2nd DCA decided in 1996. That goes to state that although affirmative defenses can be raised in a motion to dismiss, if the allegations of the complaint demonstrate their existence, the complaint in that case did not refer to the prior action. And so that's why when I say that there is a plethora of case law from this DCA that says, the defense has to appear on the face of the complaint. And in this particular case, Your Honors, the collateral estoppel defense does not. What the appellee spent most
Mr. Taylor,
of its time
just so you know, you're at 15 minutes. You can use your time however you want. It's your time, sir.
Yes, Your Honors. I guess the only other issue I would like to address is that the appellee spent much of its time in its answer brief and in its motion to dismiss trying to color the perception of the courts regarding plaintiff and the appellant's actions regarding mediations. And I think that was improper. And you can see their lack of supporting case law in their answer brief as a apparent concession that the law is not on their side, the facts are not on their side. So they have to get opinion, try to use perceptions of opinion to try to sway the court. And respectfully, Your Honor, I rely upon my briefs. I believe that the court should reverse the dismissal and specifically remand for the defendants and the appellee to file an answer. Thank you.
Okay. Mr. Taylor, you'll have 4 minutes when you come back, okay?
Yes, Your Honor.
Mr. McKay, it's all you, sir.
Good afternoon, Your Honors. May it please the court. My name is Scott McKay, and I represent the appellees, Adam and Hannah Brown. At the outset, I would say that Judge Morris, I agree entirely with what you said. I was as shocked as you were that a trial court issued an order that demanded that the bank in this case amend their complaint. They were given leave to amend. The dismissal was without prejudice. Why did they not simply amend the complaint as the trial court ordered them to do? That's an underlying question in this case. Why didn't they do that? The quote from the trial judge's order is, when is enough enough? When will equity recognize that regardless of future misdemeanors?
So I read that in the order and in your brief. I have a question about judicial notice. Opposing counsel was saying that the case law that should be controlling required, or in case, well, I guess you said all the case law, it requires 2 steps. One, before you get to judicial notice, cognizant on the face of the complaint itself, but must be this prior action that might have preclusive effect. In other words, hey, you just mentioned that there was prior litigation, so let's take judicial notice to see if it actually has preclusive effect. What case law can you present that's contrary to that says no? The defendant can just say, hey, you know what? I know about this other case law. Please take judicial notice, and I'm going to file a motion to dismiss.
Certainly, and I'll answer that in 2 ways. The first of which is, where was the objection on behalf of the appellant to take judicial notice to anything? Now, we filed an amended motion to dismiss. We had previously, before that amended motion to dismiss, properly provided a notice of intention to take judicial notice of the prior foreclosure. We did that before a prior hearing. And in that prior hearing, opposing counsel agreed that judicial notice was appropriate. So now we move on to the motion to dismiss. We put our judicial notice in that. They file a written response. They never once object at all to taking judicial notice of it. We show up to the hearing. We argue it at an oral argument. The word object is not used in the hearing once, not by anyone. So the judge, and to your question, Judge Atkinson, you asked, well, did the trial court take judicial notice? Yes, they took judicial notice. On record page 416, the court says, unless I hear something fundamentally different, I am going to continue with the judicial notice and look at it. The appellant never objects to this. Now, the standard of review, the burden, is on the appellant to make reversible error clearly, definitely, and fully to appear. How do they do that when they never once say, I object to judicial notice, this is wrong? Now, to directly answer your question, All Pro Sports Camp versus Walt Disney.
Let me pause you. Let me pause you before you get into whether or not Pro Sports was rightly decided and whether or not Pro Sports citation to our City of Clearwater case was perhaps a bit of a stretch. Typically, the process of judicial notice requires prior notification of what it is you're going to notice. You include a copy of what it is that you are requesting notice of, and then we have a nice clean record and the opposing party has an opportunity to object. In other words, it is up to the party seeking judicial notice to prove the propriety of the judicial notice. How did that happen here? Other than just saying Judge, look on your computer, you'll see that this got sanctioned previously.
Certainly. We file that it begins at record page 128. Defendant Adam and Hannah Brown's notice of intention to take judicial notice pursuant to Florida statutes 90.203 and 90.202. It's record on appeal pages 128 to 163.
All right.
Not only did we do that in advance, in a prior hearing, and I filed a notice to supplement the record on this because it wasn't part of the underlying trial court's record, but it was.
So what you're about to say is not currently in our record?
I filed the notice yesterday because I thought it was, but
it's not in front of us right now though, right?
Correct. But
Let's work with what we've got in front of us.
All right. Record page 416 is the actual transcript of the motion to dismiss hearing. And Judge Carroll says he is going to continue with the judicial notice and look at it. There's zero doubt in this case that we provided them prior notice of this. And I want to take a case square on with your honors, the Migliazzo court from the 2nd District Court of Appeal.
Well, can before you get to that, okay, so if judicial notice was properly teed up, and if indeed the trial court made a ruling that was going to take judicial notice, help me out here. How does that square with what Rule 1.140 says, which is that in a motion to dismiss, you don't consider facts outside the record?
Well, those facts aren't outside the record once you take judicial notice of them anymore.
No, they are. Outside the pleadings.
Sure.
Outside the four corners of the pleadings, and they most assuredly are outside the four corners of the pleadings in this case.
Well, yes and no. So that there's not a steadfast rule against judicial notice on a motion to dismiss. There's just not. We know that. Now, secondarily, while perhaps the bank didn't say in their complaint, we previously tried to foreclose but lost, they do put the payments in their current complaint, and those payments were barred by the prior foreclosure action. But we know that if there was a steadfast rule that said you may not take judicial notice of something on a motion to dismiss, we would think we'd see that.
Well, no, not necessarily. I mean, because honestly, it's one of those things that it's so self-evidently outside the four corners of the pleadings that I practiced for quite some time and been a judge for a little while. This is the first time I've ever even heard of someone attempting to bring judicial notice to bring outside matters in on a motion to dismiss. It just never occurred to anyone to try that. So, I mean, kudos for novelty, but I'm not sure that it wins the day to say, well, because no one has ever said, no appellate court has ever had to squarely tell a trial court that it is reversible error that the consideration of matters outside the four corners of the pleadings necessarily encompasses judicial notice is probably so self-evident that it just hasn't had to be declared yet. So work through the legal problem there, please.
Sure. And I would respectfully suggest that you're wrong. All Pro Sports Camp did this. That was on a motion to dismiss.
So here's the thing about All Pro Sports, and I'm glad we finally got there. All Pro Sports does indeed make the pronouncement that you can do this, right?
Yes.
And then waffles at the end of the opinion saying, well, even if it's proper to do this, we don't think that the copyright claims here and that the preemption issue, blah, 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 as far as Disney's, copyright infringement claim. The only citation they have for authority of that is our City of Clearwater v. U.S. Steel Corporation case, which actually says just the opposite. It literally says you don't consider that in a motion. You don't consider these kinds of things typically in a motion to dismiss. So help me through that.
Sure. And the other way, the second DCA spoke on this issue in the McWhirter-Reeves versus Weiss case, 704 Southern 2nd 214. Judicial notice was taken on a motion to dismiss in that case. I would respectfully suggest to you, Judge Lucas, that this isn't as novel a concept as you think it is. But secondarily, what is different in this case than all of the other cases is the appellant in this case did not object to this. If they wanted to be heard on their objection, if they believed the trial court got this wrong, they had an affirmative duty to object either in their brief before the trial court or surely while they stood there at oral argument. Not only did they not object, they argued what was judicially noticed. They took the preclusion argument out of the prior foreclosure and argued it. That's a good bit different than saying, no, Judge, you're wrong. You don't get to judicially notice it. You don't get to look at it. You don't get to talk about it. They argued it. the word object doesn't even come up. Now, to talk about this further, and I do want to square up the Migliazzo decision of the Second District Court of Appeal, because Judge Morris authored that decision and Judge Atkinson concurred with it. And there is talk in there about the concept of judicially noticing, but what's important, I think, in the Migliazzo decision is that the record is bare on whether or not the trial court took judicial notice of anything. It doesn't, to my reading, and I wasn't there, it doesn't look like the trial court took judicial notice. But what I will note is there's a second discussion in Migliazzo that says even if the trial court were permitted to take judicial notice of a fact, as Wells Fargo suggests, there was no indication in the record that Wells Fargo gave proper notice. And Judge Lucas, you asked me that question earlier. We did provide them with proper notice. Now, I would suggest to Your Honor that if the answer to the question at the Second District Court of Appeal is you do not take judicial notice of anything on a motion to dismiss, that discussion didn't need to take place. And I would respectfully suggest that Migliazzo does not appear to me to be a judicial notice case because there's no discussion previously that the trial court took judicial notice. It looks to me in Migliazzo like the trial court just went about doing things outside of the four corners without taking judicial notice. And I think that's a key difference in Migliazzo to here.
Well, let me try this analytical question. Maybe this will shed some light on this. What is it about judicial notice that's so special that should make it an exception to the categorical rule that thou shalt not consider matters outside the four corners of the pleadings? Why should judicial notice be elevated to this special exception that does not appear within the rule?
Certainly, because there's a mechanism within 90.202 and 90.203 allowing a party to challenge the propriety of the court doing it.
So I'll make Mr. Taylor's argument for him on that and just play devil's advocate. There's a mechanism to challenge every fact. It's called a trial or a summary judgment hearing or discovery.
Certainly.
So I don't think the fact that you get to challenge it necessarily makes it in and of itself a suitable candidate for coming up with a judicial exception to what is otherwise a pretty clear rule. Is there something else about judicial notice that might fit the bill?
Sure. There's three things, and Judge Carroll actually went through them in his parent decision. There were three components of it, and I think you have to take them all together, not individually. And all of this is in addition to the fact that the appellant did not object to this.
I heard you.
I understand. So Judge Carroll goes through three factors, one of which was the just, speedy, and inexpensive determination of issues. The second was the fact that judicial notice contains the mechanism allowing a party to challenge the propriety of it. And the third was that denying the trial court the right to take judicial notice of prior proceedings to address claim preclusion matters increases the consumption of judicial resources. And that was looked at specifically with regard to claim preclusion matters. So that might even get more narrow than just we don't take judicial notice of everything, but on a claim preclusion issue that is as narrow as the one here, a trial judge has the judicial discretion to do what he did. And he got it right. And there's no reason to have to come back on a summary judgment. And I understand the cases that talk about the difference between a motion to dismiss and a motion for summary judgment. But Judge Carroll was eminently correct when he talked about those three different factors. And why would we need to come back and do this later? We take judicial notice of it. We know what it says. And the appellant doesn't object to it. Why is this even an issue here? If they didn't want judicial notice, they should have objected. Instead, they went along with it and argued the prior foreclosure proceeding. And that's their error. And they don't get to appeal from that error when they did not make their objection to the trial court. So continuing forward on that, not only did they not...
I apologize, I was muted. Okay. Since you started a new thought, go ahead.
Certainly. Not only did they not object to it in their brief, not only did they not object to it in oral argument, they didn't bring it up on their motion for rehearing. They literally never argue the issue about the judicial notice because
right, can I change gears then to the actual merits of the dismissal? So could you walk me through, and I brought up something that wasn't really the focus, which is the default date. But can you walk me through what, I mean, in other words, if something is res judicata, it's a little more straightforward, right? This is claim preclusion. In other words, you can't bring this claim. But here we have issue preclusion. So assuming that judicial notice was proper in order to import this into the four corners that the trial was permitted to look at, why does this issue have, in other words, the issue to be precluded could be described in two different ways. One is one of damages. In other words, you cannot get damages for the missed payments between 2013 filing the complaint and then the dismissal of that complaint as a sanction. The other would be, well, you have the entire, because you alleged that as your default date or the part of the reason for the default that allows you to accelerate and foreclose, that means the whole complaint can be dismissed.
Sure. And
walk me through that.
Certainly. The judge had the ability to do that. As a matter of fact, I urged Judge Carroll to dismiss their entire complaint with prejudice.
Right. Why?
Because unlike every other foreclosure case that has ever been before the Second District Court of Appeal, the prior dismissal in this case was not only with prejudice, it was with prejudice as a sanction. You don't have any other decisions. You have with prejudice dismissals. And I'll admit that the words with prejudice, when it comes to foreclosure law,
you would agree that, or maybe not, that if what was precluded was damages for the missed payments during the time period from the time of the prior dismissal going all the way back to whenever the first missed payment was alleged in the last complaint, you would agree that the bank could file again, right, based on a later default if they're making more payments.
Right? I'm not asking you to undo.
Mr. McKay, you're into your rebuttal time now, just so you know, it's your time. Oh, I'm sorry, you got 20 minutes. What am I telling you? Keep going.
That's okay. I appreciate that, Your Honor. Thank you. I wouldn't disagree that they get to file again. And to that point, Judge Carroll could have dismissed their case outright and made them refile it in a new case number, which of course would have made the Browns prevailing parties. And we know what that means. He didn't do that to them. He could have. He said he could have. He could have dismissed it with prejudice. Instead, what he did was gave them leave to amend. That's not even an appealable order. And what did they do?
If the amendment, why does someone have to, like, in other words, you could go forward with a complaint on its face that says, hey, you didn't make payments from X date to X date. And then the simple fact that, it's a little unique. I'm trying to make an analogy here. The fact that, hey, later the bank might not substantiate that all those payments were missed. They say, well, hey, look, I paid you. Your record's wrong. That doesn't mean you dismiss the entire complaint, because the bank can say, oh, no, yeah, maybe you made payments from May to August, but you stopped making payments from August to May. The point is, if you're in default, you're in default, and I get to foreclose. The question is one of proof, really, which is, can you prove that I missed these payments for the purposes of damages? And they can't prove that because they're issue precluded. But why does that mean that the bank's complaint should be completely dismissed?
Well, and completely dismissed with or without prejudice, because those words should have some meaning. He dismissed it.
I don't care about prejudice right now. Why does the entire complaint get dismissed?
Certainly, because A, we have different amounts in controversy. B, the bank owes you a default notice for a certain period of time. And C, there is an outlying statute.
Okay, I want to get to that. Well, there's what is in the complaint that says when I'm sure that, again, I forgot, I read it a while ago, but I'm sure it just says all conditions present, or, we gave you a default notice and, accelerated. Where on the face of the complaint does it say when that default letter placed the default date?
It doesn't.
Right. So how do you dismiss the entire complaint based merely on the fact that, hey, some of these payments are issue precluded if we don't even know on the face of the complaint when the default notice, the default date was put forth in the notice?
Well, we don't know the default date in the notice, but we know the alleged breach of note and breach of mortgage payment. They allege that, and all subsequent payments. We know that date.
Yeah, exactly. All subsequent payments. So They could, for all we know, they could have said, the allegations of complaint say you stopped paying prior to the previous foreclosure action in 2013, and you kept not paying. Alternatively stated, you never started paying. And for all we know, from the face of the complaint, the default date could have been, they could have sent the default notice in 2019 or something like that. Or that doesn't make sense. Sometime after 2015. We don't know. So why is this not just an issue of, well, once the litigation gets going, they can't prove their damages between, prior to 2015, as opposed to, we got to dismiss this whole complaint. It fails to state a cause of action for the right to foreclose.
I would just argue that it's because of that preclusionary effect, because they already had those amounts at issue in the prior foreclosure. And we know that that action was dismissed with prejudice. So we know that window of payments is gone. He didn't, what he should have done, respectfully.
But the allegations in the 2017 complaint on its face include another window, or a window larger than the one you're talking about that is precluded.
Only on the back side of the payments, not on the front side. The front side payment, the initial date of default is still there. Certainly.
Okay, so in other words, you're saying, okay, so what is the importance of that? Just what is the importance of that if we don't know we just know that they want damages, there could be a deficiency judgment and I feel, to me, the dots are not connecting for me. And perhaps it's because I'm not buying into, and perhaps I should, you can explain to me, that what is operative is the first day on which the bank, in its complaint, says this payments had stopped. That is the default date, and therefore the entire complaint needs to be dismissed, as opposed to just an issue of damages that might be precluded later in litigation.
Correct.
Mr. McKay, you are actually out of time, but because Judge Atkinson has used all of your time, I'll let you respond.
Thank you, and I can appreciate that. Foreclosure law is a bit unique, and I've said it in my brief, but I'll double down on it again. District courts of appeal occasionally torture good law sometimes to bail out foreclosure plaintiffs. And that was mentioned by Judge Solario in Spencer versus Ditech. I would respectfully argue to this court that this bank, this appellant, has been sanctioned 4 separate times. 4 times. And
I think Judge Roberts gave you extra time to answer my question.
Or wrap up, whichever, but you're out of time, so do something quickly.
I understand. So the simple reality of it is what the trial judge did was eminently correct in this case. You should uphold the trial judge's ruling. They wrote good orders on it. There's case law cited. The case law is supportable. And I would respectfully suggest that the appellant's appeal be denied and that you leave the trial court record as it is.
Thank you, sir.
Thank you.
Mr. Taylor, you got 5 minutes.
Can't hear you, sir.
Sorry about that. I was muted. Specifically, I'd like to address some points raised by my opposing counsel, Mr. McKay, counsel for the appellee, regarding, one, did we object? Did we say the word object? I don't believe it's as straightforward as that, but I think repeatedly throughout the pleadings in the response to the motion to dismiss on page 327, paragraph 5, the plaintiff appellant at that says that the court is constricted to the 4 corners of the complaint. So that would in part say that you're not supposed to take outside evidence. And I believe that's just what I'm arguing for that particular issue. And we cite the McGritter case in that particular issue. And we also cite the Troop v. Redender case, 562 Southern 2nd 394 for the 2nd DCA, which goes into say that you just basically, these are the cause of actions, the elements of a cause of action for the mortgage foreclosure complaint, which is breach of the obligation. And then you have the issue of the existence of the obligation, and then you have the damages caused by that obligation. And what the court does is specifically has been cautioned by this particular court in the Holland v. Anheuser-Busch case, which says that when you're trying to terminate the litigation, you need to be very careful upon the mechanism upon which you try to do that. It cautioned that it is inappropriate to transform a motion to dismiss into a motion for summary judgment or motion for judgment on the pleadings, because that is not the purpose of the motion to dismiss. The motion to dismiss is to test the sufficiency of the complaint. It's not to make findings of fact. And I believe when the court has spoken on this, so there is that specific case law that says you don't go outside the 4 corners. So this court and this District Court of Appeals has spoken on this issue in the Seminole v. McCourt case. It says that it has a very narrow application for when you can go outside the 4 corners to take, and that imparts the 2-part test that we haven't seen satisfied in this particular case, Your Honor. Just kind of going forward, the only other issues that I believe that we should be really addressing is that the fact that this DCA has precluded specifically the outside arguments, and then to even get to that collateral estoppel argument, you have to make certain determinations, and as conceded by the appellee in their answer brief, I believe in the second paragraph, they say that the plaintiff and its predecessors, and so collateral estoppel requires a finding that the parties are the same parties in the same previous case, and so that gets to the other issue.
Okay, so the reason why I asked Mr. McKay the questions I asked, and I have no delusions that I asked it in a clear and articulate manner, that's easy to understand. But one of the reasons is because your client was really sure that they didn't have to amend. So that goes to my question. Why were you so sure that it was error to, based on if it was proper to refer to the judicially noticed information, that based on collateral estoppel, that didn't require dismissal of the complaint?
Because we weren't provided the opportunity to.
Okay, no, I want to talk about the merits, whether no one else wants to talk to me about them or not. my question is, what? Well, actually, honestly, if you don't want to talk about it, you don't have to talk about it.
No, I'll take the question, Your Honor.
Okay. I asked it of Mr. McKay. Why? And I'm asking you, why not? Mr. McKay said, well, hey, the default, you alleged the same default date. It started sometime before 2013. That's claim precluded. You need a new default date. So,
yes, Your Honor. So in that regard.
And you've got 1 minute, Mr. Taylor.
So in that regard, Your Honor, specifically, the motion to dismiss is not a fact-finding determination. It's not a part where we get to.
He's saying on its face, your complaint essentially alleges a default date that would require dismissal of your complaint, because you can't rely on that because it's those defaulted payments are precluded by collateral estoppel.
Sure. The complaint alleges the period of non-payment by the appellees. That's all it indicates. It says that from this period of time to this period of time, you haven't made a payment on the loan. And I don't think that the record supports that they were any kind of payments or alleged therein. But I think the greater issue is that because the complaint stage and what was happening was transformed into a summary judgment proceeding, basically, that you're able to file things in summary judgment. You're able to file defenses in avoidance to these sorts of things. So that's why the court, I think, improperly transmuted that one hearing that wasn't noticed for all those things that happened to what happened at the particular hearing. And I think that the court should, I rely upon my briefs, should reverse the dismissal and reinstate the complaint with the defendants to file an answer within a certain time period or remand to the lower court proceedings. Thank you, Your Honors.
Thank you both very much. I appreciate all the hard work that went into your presentation.